But the main matter that I want to inform you, and I think we owe you an obligation to tell you of the development in the case of Datuk Seri Najib's quest to fight for his case and to get released. We have just filed, only hours ago, about 1:30, we have just filed a petition to the United Nations. Okay, we have filed this in Geneva by way of digital transmission. We have done it at 1:30. And this is a document in the form of a petition by Datuk Seri Najib personally, through us, the Council. This is entitled Communication to the Working Group on Arbitrary Detention. We filed it at the Office of the High Commissioner for Human Rights, which is addressed in Geneva, and this was done today on 5th January 2023. The title of that complaint will obviously be Datuk Seri Muhammad Najib bin Haji Abdul Razak versus Malaysia. All right, versus Malaysia, because we're taking the country to the United Nations, because we are saying that the country has failed in not giving Datuk Seri Najib the fair trial that he deserves. Now, I want to read the press release first. Datuk Seri Muhammad Najib bin Haji Abdul Razak, the former Prime Minister of Malaysia, today brought a petition before the United Nations Human Rights Council Working Group on Arbitrary Detention, acronym as UNWGAD, to ask for a release or a retrial following an appeal hearing at the Federal Court which had serious defects and was contrary to the rules of international justice. He's asking the UNWGAD panel of 5 experts, 5 legal experts on international justice, to rule that the dismissal of his appeal by the Federal Court on the 23rd August 2022 was unjust, flawed, and violated his basic human rights and the Federal Constitution. The Federal Court proceedings failed to accord him a reasonable opportunity to argue his case and denied his lawyers adequate time to prepare it. As you can appreciate, he asked for 2 to 3 months or 3 to 4 months because of the change of lawyers. He was not given that. The court did not allow his defense team even to make submissions in the appeal against his sentence of 12 years imprisonment. In essence, Najib had been sent to jail without the opportunity to defend himself at the Federal Court. The final few days of the appeal in August amounted to a rushed justice when his lawyers were not allowed the time that was obviously needed to read the many tens of thousands of pages of the appeal papers or to come to grips with the 94 grounds of appeal that his previous lawyers had filed. The previous lawyers meaning Shafee and Co. Then it was taken over by Zaid Ibrahim and company. Yeah. The UNWGAD, which will hear the appeal, comprises of 5 distinguished human rights judges. They will not be called upon to decide whether Najib is guilty or not, but to determine whether his trial was fair, and if not, may call upon the government to release him or provide him with a retrial of the appeal at the Federal Court, or a retrial completely from the High Court itself. Although this decision is not directly binding, it is very influential, especially as Malaysia has a distinguished jurist who is currently a member of the working group. So we got one Malaysian in that particular working group who is a distinguished jurist. But just to be complete, she may disqualify herself because she's from Malaysia. But she may not. She may not. It all depends on whether there is a question of conflict. Some of the UNWG's strongest advocates, and this may surprise you, include the current Prime Minister of Malaysia, Datuk Seri Anwar Ibrahim, who has told the Cambridge University Press some time ago that, and I want to quote what he said, "I felt a renewed sense of hope that the wheels of justice are still churning, where UNWGAD's opinion was," and I quote again, "an important milestone on my journey to freedom." This was stated by Datuk Seri Anwar Ibrahim himself over his predicament from the first case that he had in the courts in Malaysia. As the beneficiary of a ruling from UNWGAD, Datuk Seri Najib expresses the hope and confidence that the current government will follow the UNWGAD's ruling upon the same being made available in due course. Right? That is the official statement. You have a copy of the written version. I want to just highlight a few things. I can provide you this. This is the actual petition, and it is supported by a bundle of documents which is exhibited. This will be the bundle of documents, bundle of exhibits that will go with this. In fact, all this has been filed today. Now, this, we call it the communication to the working group on arbitrary detention. I just want to highlight a few things. And I think it is important that you know, and you may want to ask me questions after this. Now, you remember, the episode at the federal court became not satisfactory as far as we are concerned. In fact, as far as any human rights lawyer worth his salt is concerned, what happened in the federal court is most unsatisfactory. Now, there was a change of solicitors and counsel, no doubt, about 5 weeks before the commencement of the appeal, which was to start sometime in, was it in October? No, August, in August, 15 August, somewhere. Now, the lawyers, the new lawyers have convinced Datuk Seri Najib, and this is because they hold that honest view that with the change of lawyers suddenly, for purposes of getting a second view or prospect of the case, they would be able to get the adjournment, because nobody could prepare a case of that massive amount of documents within 5 weeks. There's no way you can even finish reading the documents. Now, so when they appeared, the new lawyers appeared from the first day itself. They have indicated earlier that they were going to ask for adjournment for 3 to 4 months. They were refused. All right? The court refused. Mind you, this is the first time ever an adjournment request was made at the federal court by Datuk Seri Najib. He has never asked for adjournment. And you must know, there are many cases you have appeared in the federal court. Whenever an accused said, "I've changed counsel, give me time to look for a new counsel." He never even said that, "I've got counsel, but my counsel need time to prepare." Even in a situation where he said, "I have changed counsel today, give me time, I want to get a new counsel," court has never, and you can take it from me, you can record it, the court has never said no. Okay? Now here is a case where Datuk Seri Najib said, "I've engaged new bunch of lawyers 5 weeks ago. There's no way they can prepare and argue this matter. I want an adjournment." The lawyer said they need the adjournment in order to be effectively preparing for the appeal. They were denied this adjournment. All right? That goes squarely against the United Nations guidelines, namely the right to counsel means you must have counsel that is effective. No point having counsel sitting there like what happened in this case. Counsel said, I cannot argue because I have not read. There was no opportunity to read. The federal court ordered the counsel to sit there throughout the session without him contributing a single word. Okay? So, to us, this is a fundamental breach of human rights. Now, yeah, and this is not just international law on human rights. Our law in the Constitution itself, under Article 5, says, Article 5 on liberty, freedom and liberty, demands that fair trial be also accorded to any accused person. And this has already been subscribed to in view by the federal court in several cases. So our own law says you must give him the right to a counsel, the right to a fair trial. Now you remember in the federal court there was a case involving a Yemeni student who was defended in somewhere in Tawau. I became the subsequent counsel, but the lawyer who defended him actually has never defended a single case on drug trafficking. And he was actually dying of cancer. For some reason, I don't know why, he took the case and he didn't complete it. He died midway. And the poor Yemeni student was not defended well. The federal court held that that was not an effective engagement of counsel because the counsel was not effective. Therefore, the right to counsel was deprived. That was a case where actual argument was made, but not effective. It was, in fact, a very shoddy argument. And the federal court said that the right to counsel was deprived. And they ordered a kind of retrial back to the High Court. Second point I want to tell you is this. There was no allegation that Datuk Seri Najib, neither the prosecution nor the court, make any allegation that Datuk Seri Najib attempted to do a ploy to get an adjournment. This was not a ploy to get an adjournment. Nobody has accused him of that. Neither did they accuse the new lawyers. In the context of there being no accusation that this was a ploy to adjourn, we feel that taking into consideration that just a few weeks earlier, his request to get a leading Queen's Counsel by the name of Jonathan Laidlaw, that was denied by the High Court. So his change of counsel to get a second view was reasonable. If that was reasonable, you must give him the opportunity to get his counsel to be prepared. But thirdly, what is shocking is this. The court in the judgment, the federal court in their judgment, which is just 2-3 pages, blame the lawyers. You see, you shouldn't have accepted this case if you were not ready. So they blame the lawyers. Now, what has the lawyers got to do with Datuk Seri Najib? Datuk Seri Najib is the victim. He is the one who suffers. Even assuming the lawyers were wrong to have misjudged that the court would grant an adjournment, why do you punish Datuk Seri Najib? That is a fundamental breach of human rights. Because a lawyer's fault must not be taken against his client. Now, to some of you who have attended that proceeding, you may realize that as soon as conviction was made, they confirm conviction, without hearing Datuk Seri Najib's counsel, because they were not prepared, they couldn't. Although Datuk Seri Najib's counsel could not submit, the court said, never mind, you sit there, let's hear the other side. The other side has to reply. But they reply to what? They reply to nothing, because this counsel here has not spoken. So there is a double jeopardy. One is you don't allow him to speak because he was not prepared. Second is he did not speak and you allow the other side to reply, and making the situation even worse than before. Okay? This is why we say there is a fundamental breach of human rights. Now, after conviction was confirmed, those of you who are familiar with court proceeding, you will know that you have to invite counsel to address on sentence, because the appeal is on conviction and sentence. There was no invitation at all by the federal court. I think they forgot totally that there is an appeal on sentence as well. So no invitation to submit on the sentence, and that's another fundamental breach. In fact, it is the biggest breach that can occur in any criminal proceeding. Because whether it is 12 years or it could be 5 years, all that depends on the right to mitigate. And whether the 210 million, you remember in this case, there's a 210 million fine. And we would have argued, if we were the counsel, but we were not then, yeah, that the 210 million fine was totally wrong in law because it is not mandatory. But the judge thought it was mandatory. The first judge thought it was mandatory. Court of Appeal just approved it, and the federal court never heard anything and approved it. Then we have quoted various provisions of the UDHR, Universal Declaration of Human Rights, that was passed in 1948 when we became part of the United Nations. We adopted UDHR. We are not a member of ICCPR. ICCPR is also part of United Nations, International Covenant for Civil and Political Rights. Although we are not members, ICCPR and UDHR have got almost identical provisions. So when this body, this working group consider the breaches, they will consider both almost concurrently. All right. Now, first we say the refusal to adjourn means that the right to counsel of his choice was deprived of him. Second, under Article 14, we are saying the general rule is requiring a fair hearing, like our Article 5. That was also denied to Datuk Seri Najib. Then Article 14, bracket 2, is the presumption of innocence, which is also part of our law. When the federal court took that stance, that I'm not going to adjourn this matter, and it resulted in what was feared most, that they rushed through the proceedings and confirmed the conviction, that presumption of innocence was discarded by the federal court. That is against Article 14, bracket 2. Now, Article 14, bracket 3b for Bravo, denial of adequate time and facilities to prepare the defense, is also a serious breach. All right? Now, this part of it, there are many authorities. All these cases that I've quoted to you, the various rights I've quoted to you, there are cases in the United Nations that are reported. One such case is a case called Najib versus Maldives. Yeah, opinion number 33 of 2015, where they agreed with this principle. There are many others. You remember the recent president of Brazil, Mr. Lula. He's currently the president. Yeah, he got sworn in last week. He was in the prison, convicted for corruption, but there were so many breaches. He filed to the same body. All right, and the United Nations Working Group advised Brazil to release him because there were so much breaches in the right to a fair trial and so on and so on. Almost the same sort of provisions that we have raised here. Brazil initially did not follow the advice, which they shouldn't. They have to follow the advice. But what happened was, as a result of the strong opinion from the United Nations, the court in Brazil reviewed the conviction of Mr. Lula and released him in time for him to stand for election for the president of Brazil. So, if you ask me, is this effective remedy? The answer is yes. Although it is not what they call it binding, But you remember we had Privy Council before. Privy Council before, we had Privy Council in England. It is also advisory. Technically, it is not binding. But no Malaysian government has ever said we are not following it. They always follow it, because if you don't follow it, there are consequences, diplomatic in nature, as well as various other consequences that has got international repercussion to Malaysia. Yeah? Investors will not want to come in and things like, because you are not complying with human rights. And this is, if the United Nations say you are not complying with the human rights, then it is best that the country follow the advice given by the United Nations. And the last principle is, of course, the last two principles, there is no equality of arms. Equality of arms, they're using the concept of war. If you have this amount of, guns and cannons and whatnot, to be fair, the other side must have similar things. So we are talking about the courts. If the prosecution is given that privilege when they were completely ready, the Datuk Seri Najib lawyers, the new lawyers were not ready, there is no equality of arms, and therefore is a breach of a fair trial proceeding. And the last one, of course, and this was quite shocking, the case in the federal court where they denied the appeal and they confirmed the conviction was merely 2 pages, the judgment. All right, in the High Court, it was 780 pages. In the Court of Appeal, it was about 350 pages. In the Federal Court, it was 2 pages. You know why? Because they never hear the argument of the merits of the appeal, the merits of the case. So what they did was, they did a kind of judicial review. Judicial review is to see whether judges were right or wrong in the way they make assessment. But that's not an appeal. In an appeal in the federal court, you do a rehearing of everything, facts as well as the law. The federal court failed to see the difference. So this is also a fundamental breach. All right, I don't want to bore you too much with the law, but that is a short summary of what we have sent in this document that I've just shown you.